Hi, Standard 10. Here's your English facilitator till now. But I've decided to also come up with your history civics paper, history civics geography paper, and I'm going to start a series on that today. So I'm going to begin with civics. Okay, so the first thing, Standard 10, I'll be doing with you is the civics portion. Okay, so let's start. Now, before I actually start teaching you civics, I want to give you all the paper pattern. If you have a pen, you can write it down so that you are aware of what your paper pattern is. You're going to be appearing for prelims. Most of you would have appeared for your first term exam, if I'm not mistaken, and you would be knowing the paper pattern, but still, I would like to mention the paper pattern myself. Okay. So your history civics paper is paper 1 of HCG. Okay, you all know that, no? It is paper 1 of HCG. If you want, you can take this down, I don't mind. Okay, so I'm going to be discussing that. So you have parts in your paper. So your first part 1, has got 2 questions. Both are compulsory, and it totals to about 30 marks. Okay, question 1 are MCQs of 1 mark each. 6 marks are from the civics section, 3 from Indian national movement, 3 marks from the mass phase of the Indian national movement, and 4 marks are from the contemporary world. Then question 2, you have 2 marks each of 7 questions. Okay, that's a mixed question, but each question carries 2 marks. Then we come to part 2. This was in part 1 where both your questions are compulsory. There is no choice over here. Then we come to part 2, which has got 2 sections. The first section is the section of civics, which has got 20 marks, and which is question 3, question 4, question 5. So you have 10 marks each. So, but you have to attempt any 2. You will be given 3 questions, out of which you will be attempting any 2. So we get 20 marks for civics. Then we come to the second section of part 2, which is history, and it carries 30 marks. Okay, but you are given 5 questions, and you can answer any 3 from that. Now, in these 5 questions, you will get 3 questions from Indian history, and by Indian history I mean the Indian national movement and also the mass phase of the national movement, of the Indian national movement, both combined. So you'll get 3 questions from there, and you'll get 2 questions from the contemporary world. Okay, you will get 1 picture question also. That picture question could be from anywhere. So totally you will have 5 questions, from which you have to answer 3. Is that clear to you all? So you get 3 questions from Indian history, and you get 2 questions from contemporary world, totaling it to 5 questions. You answer any 3, so you get your 30 marks. So with that, I've given you the paper pattern in short. Now, there is one more thing that I would like to tell you, that while I'm going to begin with your civics section, I'm going to begin with the judiciary first. Okay. Now, in your textbook, if you see, I'll be following your textbook. And in your textbook, if you see the recommended textbook by ICSE, so I'll be following that textbook. If you see that the judiciary in your civics section is covered in chapters 5 and chapter 6. Okay, so the judiciary is chapter 5 and chapter 6. Now, what has happened is that when I teach, I prefer to combine these 2 chapters together, because sometimes you get a question, like for example, chapter 5 is the Supreme Court. Okay, everything about the Supreme Court you have in chapter 5, and then chapter 6 you have the High Court and the subordinate courts. Okay, now as far as chapter 5 is concerned, and 6 is, so 5 and 6 is for civics, and what I have noticed is sometimes you get a question where you are asked to compare. Like for example, you are asked to differentiate between the appointment pattern of the judges of the Supreme Court and the judges of the High Court, or you are asked about the qualifications. So you need to compare both, and that is the reason why I prefer to teach this. Of course, chapter wise, but I prefer to teach it in my own way, and my method of teaching is that I combine chapter 5 and 6 so that we can compare the two courts as we go along, the Supreme Court and the High Court. We'll be comparing both together so that it becomes easy for you to retain your knowledge. Okay, so the very first thing is, and of course I am going to be giving you papers. I'll be giving you notes. These notes, you may pause the video and you may take them down, or you may just listen. It's up to you. Either you can write the notes, they're pretty long, so then you can pause the video and take a screenshot and then continue, because I will be referring to my notes when I am teaching. In every module I will be referring to my notes. Okay, so I hope I made myself very clear. So let's start with the judiciary. Okay, so my first judiciary for you is this. I hope the entire picture comes up, because otherwise it will be difficult for you. Right, so we've got the judiciary and the I'll start with the explanation. Okay, so like I've shown you in that pyramid of mine, we have a single integrated judiciary system in India, which is unlike the judiciary system of USA. Okay, we are a federal setup of the government, and we have a single integrated judiciary system, and the USA has a different one. They have a double judiciary system setup, which we are not of course concerned with, but this is just to distinguish between the two. So in the single integrated judiciary system, we have the subordinate courts right at the bottom of the pyramid. Then above that we have the high courts, and above that we have the Supreme Court. The Supreme Court is supreme. Okay, that is the final authority of the judiciary. Now let's read. Under a constitution, we have a single integrated judiciary, unlike the double judiciary setup in the USA. Now, what are the features of a single integrated judiciary system? Or the question that can be asked to you is, what do you mean by a single integrated judiciary system? Because that is what we are following in India. Okay, it means that the Supreme Court is the apex court. I have given you points so that when you have to write your answers for your exams, it's very easy for you to write down points. You can give your pointers or numbers or whatever you want, and you'll get your marks accordingly. Okay, so Supreme Court is the apex court. Then below the Supreme Court are the high courts of different states. Each high court has a hierarchy of subordinate courts under it. All cases coming from the lower courts can be taken to the High Court and ultimately to the Supreme Court. A single civil and criminal system operates throughout the country. So this is the meaning of a single integrated judiciary system. It's very clear and it's put in simple words. Then why is a single judiciary system needed in our country? That can also be a question, which I posed that question over here. Because the rights of an individual need to be protected against the executive or legislative interference. Like you would be knowing, or it's important for us to know, that the Indian system of democracy has got three main pillars: the judiciary, the executive, and the administrative. Okay, so now the judiciary is the one which is very important, because it is made free, it is made absolutely, it has to be protected against the interference of the executive and the legislative. Okay, and why is that? Because it protects the rights of the individuals. Sometimes the individuals have a grievance against the government itself. So then who will listen to that grievance? The judiciary, right? So it is very important that the judiciary is free and it is fearless. Okay, now the rights of an individual need to be protected against the executive or the legislative interference. In a federal setup of government, the constitutional powers are divided between the executive, the legislature, and the judiciary. The Supreme Court prevents any action that violates the limitations imposed by the Constitution. So if the Constitution has granted a citizen particular rights, and if somebody is interfering in that right, for example, we have a fundamental right of say light and wind and air. That is a fundamental right. We all have a right to that. If there is some obstruction to that right, we have a right to go to the Supreme Court and ask for that right to be reinstated. Okay, so the Supreme Court prevents any action that violates the limitations imposed by the Constitution. Therefore, the third point, an independent and impartial judiciary. I've forgotten to write the word "and" over there. Please add it. Therefore, an independent and impartial judiciary is essential for protecting our democracy. So far so good. So are we clear about that? Okay, now I'll tell you which are the pages we have covered in your textbook, which you read by yourself. It's important to read the textbook, so you do read your textbook. I'll just give you the please open to the chapter 5, that is the judiciary. So as we go along, you will know what pages we are covering. Chapter 5, the Supreme Court. Okay, so we are beginning with that. It starts on page number 241. So you can keep it side by side. Now this entire thing that is written, I have given it to you in point forms. So when you are writing your paper, it's easy for you. Now we come to the subordinate courts. The subordinate courts are given in chapter 6. But I want you to do it. I want you to understand now, so that you understand the entire concept of what our judicial system is. Okay, so now the next page. The subordinate courts, there are 3 types of courts. You have the civil court, the criminal court, and the revenue court. I have given that to you. Now in the civil court, there is a hierarchy. And what is that hierarchy? At first, at the topmost level, you have a district judge or an additional district judge's court. So you either have the court of a district judge court or an additional district judge court. Then below him, you have the court of a civil judge. Then the munsif's court. Munsif, please add the S over there. So the munsif's court or the court of a sub-judge, that is what a munsif's court is called. And then the lowermost, at the base of the hierarchy, we have the court of small causes. Criminal courts. We come to sessions judge or additional sessions judge. Below him you have the chief metropolitan magistrate. Below that you have the metropolitan magistrate, and then at the base we have the second class judicial magistrates court. Then we come to the revenue courts. The revenue courts are the board of revenue, the commissioner's court, the collector's court, and the tehsildar's court. So this is the concept of our judiciary, beginning with the Supreme Court, and below the Supreme Court we have the High Court. Below the High Court we have the subordinate courts, all the subordinate courts. That is the pyramid in which our judiciary functions. Okay, with the base being the broadest, going up. Okay, now I want you all to learn a few judicial terms, and for that reason I want you to open to page number 244. There are a number of judicial terms which I want to explain to you, so that it's easy for you to understand if those terms come up. The first term is judgment. What do you mean by judgment? A judgment must be a decision. Have you all opened it? Page 244? Okay. A judgment must be a decision that is pronounced by a court determining the rights of the parties in the proceeding. Then what is a decree? A decree is an order having the force of law. So what a judgment the judge pronounces in the court, that is a judgment. He'll give his judgment and he'll dictate it. Once that judgment is pronounced, once it is typed out and all the legal procedures have been followed with the sign and the stamp and everything, then it will become a decree. Okay, so a decree is an order having the force of a law. That means then it has to be enforced. Then affidavit. What is an affidavit? A written statement made under an oath, swearing to the truth of the contents of the document. An affidavit means that you go to a notary who also has a legal background. He has to be a lawyer to be a notary. You go to him and you swear on oath a particular thing. Say for example, supposing you are the only child of your parents, and somebody says that no, I am also a child and I also have a right in the property. Then you go to a notary and you say on oath that I am the only legal heir, and the notary will notarize it, that you are the only legal heir and there is no other legal heir. So that is called notarizing a particular thing. So you swear on oath and then that is stamped. So to formally complete a document by acknowledgement or oath. Then contempt of court. What do you mean by contempt of court? Disrespect for the dignity of the authority of a court, including acts such as bad behavior in court. You cannot go in the court and start talking loudly or start talking amongst yourself while the judge is listening to somebody else. That is bad behavior. It is not allowed. So that is disrespect. Including acts such as bad behavior in court, refusing to answer a question as witness. If you are a witness and you refuse to answer a question, it is called contempt of court. Interfering in the business of the court, speaking disrespectfully to the judge, or refusing to carry out a court order. All these things will amount to a contempt of court. Means you are disobeying the law. Okay? Rule of law. Supremacy of law, implying that no person can be made to suffer in body or goods except for a breach of law established in the ordinary court of the land. Constitution grants wide powers to the High Court and the Supreme Court for the preservation of the rule of law. So there is a rule of law in the country. If you are an Indian, we have to follow the Indian law. You cannot ask for special privileges in the civil section, especially on the basis of your religion or caste or creed. The rule of law is same for everybody, equality. Then what is a writ? A writ is an order from the judicial authority asking a person to perform some act or refrain from performing a particular act to restore a fundamental right. Now, this is when your fundamental right has been hampered by somebody, or somebody has tried to take away your fundamental right, then you approach the court. Now for writs you have to approach only the High Court. Okay, so you approach the High Court and you file a writ. That petition over there is called a writ petition, where your fundamental right has been hampered with. Okay, so you go to the court and you say that my fundamental right, I'm not getting my fundamental right, and as a result of that, the court can issue an order. That order, which is restoring your fundamental right, is called a writ. So a writ is an order which restores your fundamental right. For example, supposing you say that I have a fundamental right to speak. Of course, by saying that you have a fundamental right to freedom of speech is a fundamental right. So that does not mean that you can publicly abuse somebody. But otherwise, if you want to object to something, and if you're doing it in a legal manner, and somebody tries to put you down, or somebody tries to hinder you from your freedom of speech, then you can go to the court and you can ask for a writ. Okay, so that is the meaning of writ. When your fundamental right is restored, the order that is passed to restore your fundamental right is called a writ, and this writ can be done only in the high courts. Okay, the subordinate courts do not listen to writ petitions. Now, who is a jurist? A person with expert knowledge of law, as someone who analyzes and comments on law, a specialized legal scholar. So that is very easy to understand. Now I want you all to open to page number 247. We have legal important writs over there. Which are the types of important writs? The important writs are, the first one is habeas corpus. What do you mean by habeas corpus? Habeas corpus means to have the body. By issuing such a writ, the High Court or the Supreme Court can get the body of any person released if it has been unlawfully detained by any person. Supposing at a particular police station or something, somebody has just caught you and put you in jail. I'm just giving you an example. And your family people say that there is not sufficient cause that you should be put in jail. Without reason you are just put in jail, then the court can issue an order, that it can issue a writ, and that writ is called habeas corpus, which means produce the body, means bring that person in front of us. So produce the body. So the court gets a chance to see, the family gets a chance to see how that particular person has been treated. Okay, so that is called, it means to have the body, means by issuing such a writ, the High Court or the Supreme Court can get the body of a person released if it has been unlawfully detained by any person or a group of persons or by the state. This writ is thus a great safeguard for the personal freedom of a citizen. Then you have the writ of mandamus. In Latin, it means we order. So the meaning of mandamus, there are a lot of words from Latin which come into the judicial system. So in Latin, mandamus means we order. Okay, so in Latin it means we order. It is a command or an order from a superior court to a lower court or an administrative authority to perform a certain duty. If the Supreme Court finds that the lower courts are crossing their limits or are not doing what they are supposed to do, or they are doing something which is objectionable, then the High Court or the Supreme Court can order and say, we order, means a writ of mandamus, that you do such a thing. And then that person or that state body has to perform it. Any administrative authority or a lower court will have to perform that, because it is a writ of mandamus. Then we come to a writ of prohibition. Children, don't take this lightly, because you can be asked about writs. You know, where you get those one-line questions where an example is given to you, and then you can be asked what writ is can be issued over here. So it's not that we are doing time pass. It's important for you to read, because I know most of you would skip this when you are reading the chapters. Okay, or maybe most of the teachers say read them by your own, it's easy to understand. If you understand this, it's from the explanation, you'll automatically remember it. Okay, now we come to the writ of prohibition. The writ of prohibition is an order issued by a superior court to a lower court to stop proceedings in a case which might be in the excess of the jurisdiction of the lower court. Means if the Supreme Court finds that the High Court is going above its jurisdiction, and High Court doesn't have a right to speak in this particular matter, then it can tell the High Court that please stop. So prohibit the High Court from continuing further. Similarly, the High Court can tell that to the lower courts, that you are crossing your limits, you are crossing your jurisdiction. This particular point, like for example, say if you want to ask something about the Constitution, or if there is a question of constitution interpretation, then the subordinate courts do not have a right to do that. But if the High Court finds that a subordinate court is doing that, then the High Court can stop it from doing it and say this is a writ of prohibition, you are crossing, this is not in your jurisdiction. Then the writ of certiorari. This writ is issued by a superior court to a judicial authority desiring to be informed of what is going on. Though it appears similar to the writ of prohibition, there is a difference. Now, what is the difference? The writ of prohibition is issued when certain proceedings are going on, and the writ of certiorari is issued after the order has already been passed by the lower court. So, if the lower court passes a wrong order and the High Court is approached not as an appeal, but the High Court realizes that this order is wrong, then they will issue, after the order has been passed, they can issue the writ and ask them that inform us what you have done, or inform us what is going on, why a particular thing has been done, why such an order has been passed, give reasons. Okay, the right to be informed. So that is called, so this is different from prohibition. Prohibition happens when the proceedings are going on and the superior court tells you to stop the proceedings. Writ of certiorari is after the order has been passed. Then if the Supreme Court or the High Court realizes that there was something wrong or something not correct, then they can ask that lower court's order that inform us what has been going on. Okay. Then we come to the writ of quo warranto. What is the meaning of quo warranto? It means by what order. It is issued when a person has usurped any office. If a person has illegally occupied a particular office, illegally he is sitting in a particular position, then and somebody else comes and makes a claim on that position that this person has no right on this particular chair. This chair belongs to me. Then a writ of quo warranto can be issued, where the court will ask them that by which order did you occupy this particular place? Who gave you the right to occupy this particular place? So by what order? Quo warranto. By what order? When a person has usurped any office. This writ thus prevents public officers from forcibly or wrongly holding a high public office. So this much for the writs. We have these different kinds of writs which you need to learn. And I want you to open to page number 256. 256, we come to a public interest litigation, which is called a PIL. Now, when you everybody is very well versed in, and we are all connected through the internet and social media and all that. So you must have heard this PIL word many times. It's a common word. PIL means public interest litigation. What is it? Let's read. A public interest litigation can be filed directly in the Supreme Court under Article 32. Okay, so under Article 32, we can file a public interest litigation directly in the Supreme Court, or you can also find it in the High Court. So PIL can also be filed in the High Court under Article 226. Okay, so we can file it in two places, under Article 32 in the Supreme Court and under Article 226 in the High Court. Now, what is it? Public interest litigation can be initiated by simply writing a letter to a judge. So there is no particular method or particular format. You can just write a simple letter to a judge, and the judge will read that, and if he feels it's important and it is in the matter of the interest of the public, he'll just put that paper, put that letter of yours as a petition. Sorry. The court may then choose to convert the letter into a formal PIL to address issues of public concern. Sometimes a court takes action on its own initiative. In such a case, what happens, such as converting a newspaper report into a PIL, as seen in several famous cases. So when the if the judges read a newspaper report and they see that newspaper report and they feel, oh, this is something wrong, then that report which is given in the newspaper, that can be converted into a public interest litigation if the judge feels that this is in the interest of the public and it needs to be addressed. Okay, so then the judge, and when a judge does that on his own, it is called as a suo moto. Suo moto means by his own discrimination power and ability, the judge decides to make it into a public interest litigation. They've given you a famous case like the Delhi air pollution case. There was a Delhi air pollution case where PIL was filed suo moto by a judge. A PIL is a tool for judicial reviews of the court. It aims at ensuring justice to all. Any citizen or agency who is capable can file petitions on behalf of those who cannot or do not have the means to do. Now, why is this public interest litigation so important? Some people may not have the means to do it. They may not have that much of money. They may not have that much of knowledge. They don't know what to do. And because of that, the only thing they know is they can just write on a piece of letter that this is my complaint. So if a person does not know legal language, or he does not know the legal formalities or what he has to do, that does not mean he will not get justice from the courts. The judicial department is such that you will get your justice, even just by writing a simple letter. So that is the reason why public interest litigation is so important. Okay, so that is the means of any citizen or agency who is capable can file. Now, who will file? Supposing you write a letter and you don't know what to do, you find another agency, you find anybody, say a small law firm, or you just find a lawyer and he says, okay, I'll file the litigation on your behalf. Okay, so that person can file it on your behalf and it can go for as a public interest litigation. Of course, you cannot, nowadays there are too many PILs happening in the courts, as a result of which the judiciary has become very strict about public interest litigation, and you have to prove why it is a public interest litigation. The very word PIL means public interest litigation. That very word itself shows it has to be in the interest of the public, not in your individual interest. It is for the public at large. For example, this air pollution case, it is for the interest of the public at large, and therefore the judge decided to suo moto take it up as a PIL. You cannot say that I have been individually wronged and I will file a PIL. No, PIL is for public interest, for everybody, for the entire community or society at large. Okay, so that is a public interest litigation. So with that, I have completed I've given you a gist of the judicial terms. Then I've explained to you the judiciary. We begin with the base, and then we go up in a pyramid like structure, and we reach the top of the pyramid. We have the Supreme Court at the apex. That is how we have done. Then I've given you the subordinate courts and the different types of subordinate courts. And I'll leave you all over here with this first module of mine. And before you come back for my second module, I am very strictly going to instruct you, please learn. Read what the textbook says, and if you can, you make your own notes. You're free to do that. If you don't have the time to make your own notes, you can refer to my notes and you can learn them by heart. I can guarantee you that you have all the points with you, and you will be able to answer any question that is asked from this. And I have mentioned the judicial term pages to you. Learn them by rote. Learn them by heart. You are supposed to know all the writs, and you are supposed to know all the judicial terms. Okay, so with that, I've said that very sternly in the hope that you all please learn before you come back for my second module on judiciary. And here's your history facilitator for ICSE also wishing you a goodbye, and see you all next time. Bye everyone.